read this, but I will ask for those of you who are joining us to introduce yourselves using the chat box. If you could just tell me what city you're tuning in from and tell me a little bit about your business or your business idea, I'd appreciate it. All right, so I am a licensed attorney here in California, as well as the state of New York. I am, as Gabrielle said, a proud Silicon Valley native. These days, I call Monterey County home. My family has been in Monterey County since the 70s when they came with the military. Like many other counties in California's Central Coast, Monterey County's economy is really supported by local independent businesses. Entrepreneurship is really one of the spirits of Central Coast, I would say. So I am excited to speak with entrepreneurs and to be able to assist them achieve their business goals. My three main practice areas: corporate compliance, corporate governance, and contracts. What's most important or most interesting for you all today is my experience in trademark law. So we will begin. I have to make a disclaimer that this is not legal advice. This is just factual information. So please do not construe anything that we talk about today as legal advice. If you want legal advice, we can talk about that offline. Okay. So thank you. Okay. Colorado, San Luis Obispo, equipment leasing, finance, author, self-publisher of a cookbook. Amazing. Awesome. Okay. If you all have any questions, please feel free to put them in the chat at any time. Intellectual property. So trademarks are a type of intellectual property. So we'll start there. Intellectual property, or IP, refers to creations of the mind. Intellectual, i.e., creations of the mind, okay? And intellectual property law allows these creators to earn recognition or financially benefit from what they have invented or created. There are four main branches or four main types of intellectual property. You have trademarks, patents, copyrights, and trade secrets. They are all types of intellectual property, but they all have their own unique characteristics, requirements, rights, protections, obligations, etc. A trademark refers to a name, word, or symbol that identifies and distinguishes a company's product or service. For example, the Nike sign, whether it's the words Nike or it's the check mark, that is a trademark. When we see the Nike "Just Do It" slogan, we immediately identify the Nike brand, their products, the quality of their products, their corporate initiatives, etc. A patent refers to a technical invention. So this is these are inventions in your science, engineering fields. For example, Apple has a patent for multi-touch screen technology. Third, which is of interest to one of our guests, is copyrights. A copyright refers to an artistic creation. For example, Disney owns the copyright to the Lion King movie. And finally, you have trade secrets, which refer to business information that has commercial value because it is kept secret. For example, KFC's special blend of spices and herbs. Now, it is very possible for one company to maintain many different types of intellectual property. For example, Coca-Cola. Coca-Cola, the name Coca-Cola, as well as that stylized script you see, as well as that bottle, those are all examples of trademarks. Coca-Cola also has a patent for the process in which they make artificial sweetener. They also have a copyright on their "I Wish I Could Buy the World a Coke" theme song and commercial. And finally, there ingredients for their artificial sweetener is considered a trade secret. Again, many different types of IP, but they are all different. So understand that lawyers specialize within each type of IP. Understand that your trademark lawyer may not be able to assist you with your patent applications and vice versa. While we're on the topic, do you need an attorney to submit a trademark application? Not everyone is required to have an attorney, but you really, really should. Submitting a trademark application with the United States Patent and Trademark Office is considered a legal proceeding. And like any other legal proceeding, you would want to be best equipped with good legal representation. When you hire an attorney to assist you with the trademark application process, not only are they providing you advice on trademark law in general, but they are going to conduct a trademark clearance search before you file the application. In other words, making sure that your mark exists and making sure that there is a good likelihood that your mark will be successfully registered. They will prepare your application for you, prepare it correctly, hopefully. They will respond to any correspondence from the USPTO. They will enforce any trademark rights that you acquire. They will help you maintain your trademark by filing the maintenance documents that are required of you. They will represent you at the USPTO appeal board if necessary. And they will help shield you from fraudulent solicitations. Once your trademark is registered in the USPTO's database, your information becomes public. Public information it is used by individuals to try to solicit unnecessary services and associated fees from you. We'll talk about that more. So let's talk about trademark law, the law that establishes trademark rights. Law is generally created in one of two ways. It's either through common law, which is created in the courtroom through judicial decisions, or it's created in written text, created through the legislative process or through agency rulemaking. Within those areas of law, or those areas of law exist on both a federal and on a state level. Understand that with trademark law, you have much more protection at the federal statutory level than you do at any other level. Now, if federal trademark law exists, what's the point of state trademark law? Let's take California as an example. California Business and Professions Code Division 6 Business Rights it's a statutory text that establishes California's own trademark law. On a federal level, we know that cannabis is a controlled substance, but in California, it is not a controlled substance. So a California business owner of a cannabis production facility may not be able to get their business's trademark registered on a federal level because cannabis is still an illegal substance on the federal level. So instead, that cannabis business may register their trademark with the California Secretary of State because it's permissible in California. And although they won't have all of the protections of federal law, at least they will have some protection. Okay. For international businesses, there is something called the Madrid Protocol. And the Madrid Protocol provides one application for you to be able to have your trademark registered and recognized by about 128 member countries. Okay. So what exactly is a trademark? Let's drill down into that. We already said it's a word, phrase, symbol, or design that identifies your goods or your services. But it also performs a couple of different functions. So number one, it identifies your business. When we see that logo, we immediately identify or associate the logo with your business. Number two, your trademark distinguishes your products or services from competitors. So when we see your logo, we know that it is your business and it is not someone else's business. And then having a registered trademark, it helps protect against counterfeit and fraud, right? Having a trademark allows your customers to be able to spot knockoffs, right? For your customers to be able to notice that that design isn't quite right. This must not be either a legitimate product, or this good or service is not associated with the brand the company that I'm familiar with. Now, how do you own a trademark? By using it. As soon as you use your mark in commerce, that's a defined term, and we'll talk about that. But once you use your mark in commerce, you automatically own your trademark. However, you do not get certain protections and rights until you register your trademark with the United States Patent and Trademark Office. Now, you're not required to register, right? But again, if you want certain protections under federal law, then you will need to register your mark. There are different types of marks or of trademarks. Trademarks refer to goods. Service marks refer to services. However, people colloquially use trademarks to refer to both goods and services. You have trade names. So instead of listing your company's entire legal name on every single document or piece of marketing and advertising, you might use a trade name like Walmart. Certification marks. Here in California, we've all seen this Real California Cheese certification mark, which indicates that certain standards have been met. There is a collective mark referring to membership or union, and then you have trade dress, which refers to distinctive packaging. So why do trademarks matter to your business? Because you work hard to establish your business and distinguish yourself from other businesses. Customers recognize your business by its name, its logo, its branding. So if you have a competitor move in next door with a similar sounding business name, a similar looking logo, providing similar products or services, there's a good likelihood that your customers will get confused, right? You don't want your competitors to attract your customers, right? Unbeknownst to your customers. You don't want there to be any confusion between you and your competitors. So the benefits of registering your trademark with the United States Patent and Trademark Office is, number one, that your trademark gets listed publicly in the USPTO's Trademark Electronic Search System, abbreviated as TESS. Why does it matter having your trademark listed in this public database? Well, you are giving the whole wide world notice that you are the rightful owner of a trademark, okay? In the event of litigation, a registered trademark owner has a legal presumption that they own and use their trademark. So if someone is infringing on your trademark, they're using your mark, and you decide to sue them in court, your registration with the USPTO establishes a legal presumption that you own your trademark. You don't have to prove it in some other way other than just by showing that you are the registered owner. Another huge benefit of having a registered trademark is that you can work with other government agencies to defend against trademark infringement. For example, you can work with the US Customs and Border Control to stop the importation of goods that infringe on your trademark, aka knockoffs. And finally, your registration can last continuously so long as the trademark continues to be used in commerce and that the trademark owner files the required maintenance documents. You cannot register your trademark and then never use it again and expect to maintain your ownership and your exclusive rights over that mark. You have to continue to use it in the marketplace. There are a couple of different requirements for a trademark. It has to be distinct. So it cannot have a generic name like creamy yogurt, right? There needs to be a distinctiveness to your mark. Number two, the trademark it must not be essential to the use or purpose of the good. For example, you cannot trademark the word run, right? Or spray. There's a non-functionality requirement. And then finally, you'll hear it again and again, your mark must be used in selling the good or providing your service. All right. So how do you actually register a trademark with the USPTO? First, you have to understand that approval is not guaranteed and fees are non-refundable. An application can cost at least $250, and that's per class. We'll talk about classes later on. You can expect the trademark registration process to take at least 12 to 18 months, and that's if everything goes smoothly. So what's the general process? Well, number one, you're going to select your mark and you're going to identify its format. Format means, or examples of format is either words, so the words Nike, N-I-K-E, perhaps it's the stylized script of Nike, or perhaps it's the symbol, right? What's the format of your mark? And then you have to identify the goods and services that are associated with the mark. So when you submit your application, you indicate my mark is associated with goods in beverages or leather goods or some other category, but you have to identify specifically what category of goods or services your trademark relates to. After you identify your mark, then you are going to perform a clearance search and test. That is such a critical step, and I'm going to walk you all through that next. You want to make sure that your mark isn't already used or available, or you want to make sure that your mark is not already registered and that it is available for you. Next, you're going to determine your application filing basis. So you generally have two options. When you submit your application, you are submitting it saying that, yes, I have been using my mark in commerce, or no, I have not yet used my mark in commerce, but I have intent to do so in the near term. Depending upon which application you submit, what influences your timeline. You'll prepare your application and you'll submit your application. After your application is submitted, the USPTO has its own team of attorneys, and a USPTO examining attorney will be assigned to your application, and they will review your application to determine whether it is appropriate for your trademark to be registered. It takes them at least 3 months to respond, not to approve, but to respond to your initial submission. If the examining attorney identifies any additional information that's needed or any potential legal problems, they will send an office action. You have about 6 months to respond to any office action. After you work with the USPTO examining attorney to get them all of the information that they need, which might include a statement of use, then your registration will be published for opposition. What does that mean? Well, similar to when you created your business organization, whether you created an LLC or a corporation, your state of incorporation probably asked you to publish the formation of your business. This is the same concept. The USPTO will publish that your mark is going to be registered by a certain date, and if anyone believes that they are the rightful owner of that trademark, then they must file an opposition. After the window for opposition or for yes, the window for opposition closes, then you will receive a certificate of registration and your mark will be registered with the USPTO. And then finally, and continuously, you have to maintain your registration by filing your maintenance documents and using your mark in commerce. Okay, so first step is performing your clearance search and tests. Now, a common reason for denial is that the mark is too similar to an existing registered mark. So when you perform a clearance search, it needs to be broad enough to find anything that would likely cause confusion, but it also needs to be narrow enough to a manageable number for you to be able to evaluate potential confusion. So if you have a trademark, if you already have a registered trademark, or you want to register your trademark, I invite you to follow along with me on your end. I'm going to walk you through how to perform a search on USPTO's tests. So I'll give you like a minute to open your browser, and you're going to go to uspto.gov/trademarks/search, or you can just Google USPTO tests or USPTO trademark database. When you get to this page, you're going to start here at the bottom where it says search our trademark database. You're going to have different search options. I would encourage you to first start with the basic word search, okay? You can search whatever trademark you are interested in registering, or any trademark that just you want to search right now. Just type it into the search term and then submit your query. I put in Nike here, and these are all of the results that populate for Nike. Now on the results page, I want you to take note of a couple of different pieces of information. Whenever you submit an application for registration, you are automatically assigned a serial number. Once your trademark is successfully registered, you will then receive a registration number. So just by looking right at the results page, I can already tell which trademarks are active registered trademarks and which trademarks are not fully registered. There is a column here, live or dead. If you abandon your trademark application, it may show up as dead, or if you abandon your registered trademark, it will also show up as dead. And then here for classes, that indicates whatever class is associated with your goods or services. So if you select any results, this is what the individual registration page is going to look like. You see that the word mark is Nike. You see the different goods and services that are associated with this trademark. You see the serial number, the filing date. You see the attorney of record. So when you are vetting potential trademark attorneys to assist you with your trademark registration, you can search their name and test to see all of the different trademarks that they are associated with. And that might help you in your decision making. At the bottom, you also see a description of the mark. So the mark consists of a stylized curved line design with the word Nike directly above it. All right. And then finally, at the bottom, you see register. And here it says principal. So the USPTO has a principal register and it has a supplemental register. The principal register is where you want to register your mark. It affords much more protection. So we just completed a search as a basic word search, but you can also search by design. Okay. So here, if we search goose, these are all of the different trademarks that come up with some type of goose design. And if we select one here, so the page is similar, almost exactly the same as the results we saw for a basic word search. So the information is the same, it's listed the same, it's just a matter of how you find the information via your search terms. Okay. Oh, and very importantly, here you see the owner. Towards the bottom a little bit, you see who the listed owner of the trademark is. Again, you see there's a name and there's an address. Understand that this is publicly available information. So we want people to use public information respectfully, but that's not always the case. So beware of scam solicitations. Okay, after you've identified your mark and you've run a clearance search, then you will access the application. There is an option for a paper application, but likely you will have to submit an electronic application. And you first do that by creating an account with the USPTO. The application is abbreviated TEAS, TEAS if you want to pronounce it that way. There are two different when you select your application, there are two different filing bases. You can either file saying you have used this mark in commerce or that you intend to use the mark in commerce, okay? Now, if you have not yet used your mark in commerce, you can file an intent to use application. And what happens is you get a window to start to use your mark. So when you file your application for a trademark, no one else can file an application for that same trademark. You kind of take your spot in line while you're getting it together. You have about 6 months to begin to use your mark in commerce and then submit to the USPTO what's called a statement of use. And that is when you provide proof that you are using your mark in commerce. Okay. You provide that proof via a drawing and a specimen. So a drawing is what the trademark looks like. The specimen is how your customers will see the trademark in the marketplace. So the specimen might be a label that's attached to your bottle or to the packaging. For services, it might be your logo on brochures or on your website. Okay. Your application will ask you to identify a trademark class. So you see here the darker blue, these are the classes for goods, and to the right are the classes for services. Understand that you will submit an application. One application can have many different classes listed, but understand that you have to pay per class. So the application is about $250 or a little bit above that. So if you decide that your trademark relates to, say, number 7 machinery, well, number 6 metal goods, number 7 machinery, and number 8 hand tools, you have to pay $250 for each class. You also have to identify the class correctly. Remember, there is a USPTO attorney that's going to review your application. So if you are selling jewelry, but you have a clerical error, right, and you selected musical instruments, the USPTO examining attorney is going to deny your application and ask you to select a different class. There's a question: which class would a cookbook publisher logo go under? So I can't advise you exactly which class you should select, but it all depends. So your business, publisher. So as a publisher, would you say that you are providing the good, or would you say that you are providing the service, right? Because it depends. Okay. After your application has been submitted, what happens? The USPTO examining attorney reviews your application. If all of the requirements are met, your examining attorney will submit your registration for publication. If there's something that needs to be corrected, the examining attorney will send you something called an office action. An office action is a formal legal document, and you have to respond to it typically within 6 months. If you miss a deadline, your application will be abandoned, and there's a $150 fee to revive an abandoned application. So it's really, really important that, number one, you fill out the application as correctly as possible the first time, right? And number two, that should there be anything that needs to be corrected, that you are on top of it, and you are checking your email, right? You receive the notice and that you respond to the notice appropriately. There are two different types of office actions. Generally, there's a non-final office action, and then there's a final office action. With non-final office action, some problem has been raised for the first time. If you fix all the problems, the application will proceed. Otherwise, you will receive a final office action. And a final office action is issued when a legal problem has already been raised at least once. If you fix all the problems, the application will proceed. But if not, the application will be abandoned unless you file an appeal with the Trademark Trial and Appeal Board. So common mistakes and reasons for denial of registration typically fall into two categories. You have non-fixable mistakes, and then you have fixable mistakes. Non-fixable mistakes cannot be fixed, and you have to start your application from square one. Non-fixable mistakes include misidentifying the trademark owner, misidentifying the class of goods and services. Perhaps the trademark conflicts with an already registered or already applied for trademark, or the trademark is too generic. A fixable mistake is the specimen you submit. So remember, a requirement for trademark registration is that your trademark is used in commerce in a way, right, that is associated with the goods or services that you provide. So if you are providing a good, your logo has to be used in conjunction with you selling that good. So your logo needs to be on the packaging, or again, like we talked about, the packaging, the bottle, if it's a service, on brochures, on your website. So if you are using, if you submit a specimen that does not sufficiently prove that you are using the mark in commerce, you have the ability to submit a new specimen. Scams. Okay, beware of the scams. Your information is public. Right after you register right after you submit your application for registration, your application information is listed in the test database. What will happen is that companies will reach out to you with these official looking notices. They look like they're from the USPTO office, but they are not. And the notices basically are trying to encourage you to hire the company to perform some service that is not necessary, right? That is not actually needed or required. So you have to be aware of that. The USPTO has an entire web page on their website dedicated to the different types of scams that are associated with trademarks. Okay, so your trademark is registered. Now what do? The answer is not nothing. Okay, let's first talk about using the trademark symbol as compared to the registered symbol. You probably see, I'm sure you've seen these symbols quite often, and perhaps you don't know what the difference is. Well, let's start here. You're not required to use either symbol. You're not required to use TM, and you're not required to use the registered mark. However, if you do use it, it could help you protect against trademark infringement. People use the TM mark to indicate a trademark that has not yet been registered with the USPTO, but you're just generally giving people notice that, hey, this is my mark, I'm claiming it, and I intend to register it with the USPTO. The R mark is typically used by trademark owners, and they're indicating that I have a registered, valid, and protectable trademark. If you use these marks and you end up having to litigate trademark infringement against an infringer, your use of those marks may afford you some benefits in litigation, right? You're giving notice. I use R or TM on my trademark, indicating that this mark is owned by someone. This infringer intentionally infringed on my trademark, right? So you might be awarded more damages because now it's intentional infringement. So you're not required to use those symbols, but it is helpful. You are required to file what's called maintenance documents. Within your 5th and 6th year of registration, you have to submit what's called a Section 8 Declaration of Use or Excusable Non-Use. And basically what you're saying in this application is, yes, I own this trademark. I intend to continue to own this trademark, and I have been using my mark in commerce. In that application, you have to submit a specimen proving, once again, how you are using your mark in commerce. After between your 9th and 10th year, there is, you have to submit another maintenance document. There is something called a Section 15 Declaration of Non-Contestability. So after 5 years, if you are continuously using your mark in commerce, you can basically assert non-contestability, meaning someone cannot challenge whether or not you are the rightful owner of your trademark. That option is available after 5 years. In addition to filing your maintenance documents every 5 years, you are, as a trademark registered owner, you are required to update the USPTO on any changes in the information associated with your trademark or any changes in the way you use your mark, okay? And you do that using a Section 7 request for amendment. How do you protect your trademark? Number one, actively monitor for dilution, okay? Aspirin and escalator used to be trademarks, but they lost their registration because they were used generically. So Google discourages people from saying Googling as a verb, right? Instead, Google encourages people to say, use Google search engine. They're trying to mitigate dilution of the trademark Google. In addition to monitoring for dilution, you also need to monitor for infringement. So if you see any unauthorized use of your trademark in any way that's likely to cause confusion, deception, or mistake about the source of the goods and services, then you have a responsibility to take prompt action. What type of action would you take? You typically have 3 options. You can send a cease and desist letter. You can file a notice of opposition with the USPTO, letting the USPTO know that someone is infringing on your trademark. And you can file a trademark infringement case in court. That's a civil action, and you can file it in either state court or federal court. And generally, in a trademark infringement suit, the plaintiff, the trademark, the person who feels that they have been wronged, the plaintiff has to prove, number one, that they own that valid trademark and that their right to use the trademark has priority over the defendant's rights. And number three, the plaintiff has to prove that the defendant's use of the mark is likely to cause confusion to consumers as to the source of those goods or services. In an infringement lawsuit, the court might order the defendant, the person who is alleged of wrongdoing, to either stop using the trademark, to destroy any articles that would infringe on the plaintiff's mark. So any counterfeit items or knockoffs that the defendant might have made or have in their possession. The court might order the defendant to pay monetary relief for damages. So any profits that the defendant made from infringing on your trademark, the court might order the defendant to pay that money to you. And additionally, the court may order the defendant to pay the plaintiff's attorney's fees. Now, understand that abandonment is a defense to trademark infringement. So if you successfully register your trademark, but then you don't use it again for 5 years, and some new person decides to use your trademark, if you sue them for trademark infringement, they can assert the defense that you abandoned that mark and that you should not be entitled to trademark protections, or you should not be entitled to any rights associated with being a trademark registered owner. Now, the USPTO has a trademark assistance center that can help you with limited tasks, or so they can provide you with general information about registering a mark. For example, how to locate the applications, how much they are. They can provide you with resources that explain like trademark law. They can provide status updates on your application. They can help you navigate through the online portal or through the test database, but they cannot provide legal advice to you. And examples of legal advice is how to respond to USPTO actions, right? How to conduct a clearance search. They cannot review your specimen for you ahead of time and let you know whether or not that is acceptable before you file it. They cannot tell you which class you should select for your goods and services. That is all considered legal advice that you would need to hire an attorney for. Okay. And that is trademark law. So are there any questions? Okay, well, if you don't have any questions for me, I do have questions for you. Oh, okay. So from Julia, the question is, what are the most common challenges you have helped clients overcome? I think the biggest challenge is making sure that it's probably been used in commerce. It's making sure that the trademark can actually be registered, meaning it has all of the elements to constitute a valid trademark, and then using that mark in commerce. A common reason for denial of a trademark application is that the trademark is too similar to an existing registered trademark. So the very first challenge out the gate is making sure that your trademark distinguishes itself from others, that it is not likely to cause confusion, that it's not likely to be confused with another trademark. So, and then making sure that whatever mark you are selecting has all of those elements, that it's distinct, that it's non-functional, right? That it's used in commerce. Use in commerce is huge, because you have to know, you have to use your mark, right? So helping clients identify all of the different ways that they can use their mark. You know, maybe your business is not at a point where you have brochures and tons of marketing materials that get printed on swag bags and stuff like that. So finding economical options for clients to be able to use their mark in commerce in a way that satisfies the trademark requirements. Okay. I see here a question about the cost. So yes, filing a trademark application is expensive. It's expensive, and it's even more expensive if you're not successful. So the fees are non-refundable. So it's important that you are sufficiently equipped as you're going throughout this legal proceeding. Yeah. Okay. It costs to file the trademark. It costs to maintain the trademark. It does cost. Okay, so just to make sure that you all have retained the information, I have a short 5-question poll that I would like everyone to take. Gabrielle, are we able to launch the poll?
Yes, ma'am. Let me go ahead and pull that up.
Okay, so questions came on your screen. Just answer them to the best of your ability, a little bit of a quiz, and when you're done, hit submit, and we'll move on. And then Gabrielle, are we able to tell when the poll is completed?
You know, it looks like 2 of 4 have participated.
Okay, so let's just go through the answers. So number 1, which trademark application is used if the mark has not been used in commerce before? The answer is the 1B application, the intent to use. What is the acronym for the USPTO's trademark database? That is TESS with a T, Trademark Electronic Search System. Number 3, trademark owners are legally required to use the trademark icon or the registered icon, true or false? That is false. Trademark owners are not legally required to use the symbols, but they should. Number 4, after a trademark is registered, when must the maintenance documents be filed? That is every 5 years. And finally, when are responses to office actions due? That is within 6 months. Okay, so I hope you all got A++s. If you all have additional questions for me, you can contact me on LinkedIn. Miss, who had the question? Miss Engel. If you want to talk more about your specific trademark and which goods and which classes you should be selecting for your publishing company, you can also contact me here as well. We have a link to my Calendly for a consultation. If there are no other questions, I really, really appreciate you all's time. Thank you for tuning in. Gabrielle will put some contact information here in the chat so you can copy and paste. And other than that, I'm wishing you all a wonderful rest of your day.